Well, police can collect DNA from criminal suspects without getting a warrant. The U.S. Supreme Court handing down that ruling today. The justices say that DNA swabbing does not violate the Fourth Amendment, which protects people from unreasonable search and seizure. At least 26 states and the federal government allow genetic swabs to be taken after a felony arrest without a warrant. Matt Markham live in the newsroom now and explains that this could open the door for DNA collection before you're convicted of what is considered to be a serious crime. Matt?
Yeah, Dory, that's the issue most concerning to privacy advocates. Now, under this ruling, if you're only arrested, your DNA could be taken, whatever the reason, if you end up being found guilty or not. Those against the court's decision, however, wonder how your DNA could be used against you later in life if it's on file. Police believe the more DNA records they have, the safer you will be.
This is a great crime-fighting tool, and honestly, what it is, it's fingerprints in the 21st century.
Albany County Sheriff Craig Apple sides with the majority on the Supreme Court's ruling for what he calls proof-positive evidence.
I can't tell you how hard it is, from being somebody who has taught forensic science and has worked in the forensic field for years. It's very hard to lift a very good print.
But an arrest does not equal guilt. The New York Civil Liberties Union believes with this decision, it could.
What it's going to do is just create a group of the usual suspects that they'll round up that have a close match.
Instead of being a benefit to solving crimes, Chapter Director Melanie Trimble thinks a larger pool of personal information can flood the system.
We don't have really good standards that everybody adheres by as far as collecting, storing, and analyzing DNA data. So while we think it's a great, reliable law enforcement tool, which it can be, there are serious protections that aren't in place.
Apple anticipates cold cases closed with more DNA stored.
You're going to have crimes that have occurred dozens of years ago, or even maybe just dozens of days ago, solved. Easier, quicker.
Though the court ruled it reasonable to swab arrestees for DNA for serious crimes, what's unclear is what's considered a serious crime. DNA has solved countless crimes, but not everyone believes the science is perfect.
Why, are we going to be collecting on thousands and thousands of innocent people?
Well, New York is not one of the 26 states, at least 26 states, which collect DNA samples from some arrestees. Lawmakers could write legislation, though, for it to be legal now that the Supreme Court has set the precedent. In the newsroom tonight, Matt Markham, CBS 6 News. Greg?
Well, thank you, Matt. Our fact finders wanted to know more about DNA testing. They found that New York State launched its DNA database in 1996. Taking samples then from murderers and certain sex offenders. Lawmakers have expanded the database 3 times. Governor Cuomo signed a bill into law last year requiring a DNA swab from convicted felons and those convicted of misdemeanors like shoplifting. The state's database has been used in nearly 3,000 convictions since 1996.